Juris Vodcast with Scott Pearce.
Is it okay for the cops to put a global positioning system device on your car without first getting a warrant? Suppose they want to put it on your clothes. What then? The Fourth Amendment to the U.S. Constitution is supposed to protect us from unreasonable searches and seizures. But is putting a GPS tag on somebody a search for Fourth Amendment purposes? As our technology becomes more powerful, issues like these are going to become commonplace. So far, there is not a lot of case law on this point. There's a 2007 case from the Seventh Circuit called U.S. versus Garcia. The defendant had a history of drug convictions involving meth. The cops heard he was back in business, and they put a GPS unit inside the bumper of the car he was using. When they retrieved the GPS, the information in it led them to more evidence. The Seventh Circuit was called on to rule as to whether or not this evidence should be excluded under the Fourth Amendment. The court held that what the cops did in this case did not constitute a search, so the Fourth Amendment did not apply. The written opinion from this Seventh Circuit case is well worth studying. It is a thoughtful, fairly scholarly opinion with a concise yet comprehensive summary of the applicable precedent. The court takes care to limit the decision to the facts presented by the case at bar. It indicates that should the government seek to make the practice of affixing GPS tags more systematic, there might be a Fourth Amendment problem. Although I would hold law enforcement to a higher standard than the Seventh Circuit, their reasoning is logical and honest. Since 1967, the Supreme Court has held that the Fourth Amendment will have to evolve with the technology. Expect to see many more cases like U.S. versus Garcia in the near future.
Juris Vodcast is a production of Nuclear Podcast. Creative Commons Attribution, Non-Commercial, No Derivatives.